All right, welcome back. I hope you enjoyed your lunch. We're going to go ahead and kick off the introductions to our keynote speaker, the highly anticipated Rick Friedman. Bob Simon just touched me. I feel honored as he walked by. I'm never going to wash these pants again. But I'm going to turn it over to Jeff Wells and Spencer Lucas so they can introduce our honored keynote speaker today.
Thank you, Ben. It is truly an honor for Jeff and I to introduce our keynote speaker, Rick Friedman. Rick is, without question, one of the most decorated and respected trial lawyers in the entire country. And for myself, it's really a special honor because I'm a guy from a place called Port Orchard, Washington, where my granddad used to say, there ain't no port and there ain't no orchard. And Rick Friedman is practicing law in Bremerton, which is the next town over. And Jeff Wells is from Bainbridge Island, which is the island right outside of Bremerton. So we're three guys from Kitsap County, and we're here today, so it's really a special thing for us. When I was a young lawyer, someone gave me a book, Rules of the Road, which is really the seminal trial lawyer's manual. And it was groundbreaking for me, and it really inspired me to want to become a trial lawyer. And the author was Rick Friedman. I looked him up, and I realized he was working in Bremerton. And it was a shock to me that such a successful trial lawyer could come from my home area. And it's really been an inspiration to me. Now, Rick, as you heard, he is a graduate from Harvard Law School. And he ended up going from Harvard to a place called Sitka, Alaska. And if you've never heard of Sitka, you're not the only one, but I looked it up on the map, and it's way down kind of on the panhandle of Alaska. And not exactly a booming legal market, I would presume, but Rick took this one lawyer office, his own shingle, and turned it into one of the most prolific American law firms really in history. And it really is a credit to Rick as not only a trial lawyer and a teacher, but as a human being. And part of what is so amazing about Rick Friedman is not the accolades and all the successes that he's had, but his demeanor, his professionalism, and really the grace and humility that he brings to the trial advocacy that we see. So Rick saw all my notes and he said, don't take up all my time. And I said, well, it's all your verdicts. I got to kind of touch on some of them. But just to give you an example of Rick Friedman's level of success in fighting for victims of injustice and fighting for the little guy against corporate America, $152 million verdict for a breach of contract case. And this verdict came out of not Los Angeles, not Las Vegas, but Anchorage, Alaska. That's just incredible. And that was a case involving an insurance agent where he had an independent agency agreement and it was terminated in retaliation for his refusal to engage in dishonest marketing practices. Those are the kind of cases that Rick Friedman is known for. $104 million verdict against a drug manufacturer and distributor, and that was in Las Vegas in 2011. $84 million verdict for bad faith denial of disability benefits. And Rick has really paved the way for disability benefit cases, including another verdict in Nevada, $61 million. He's had a $42 million verdict in Kentucky. So all over the country, Rick is fighting for victims of injustice and really having results that are out of this world. But not only is he a great trial lawyer, but as an author as well. And Jeff's going to talk about that.
Okay. Thanks for coming, Rick. We're really honored to have you. I was telling some of the Pepperdine students that one of the things when we went here, some of us felt like people on the outside of Pepperdine Law School look at the location, the beach, the pool, and they go, wow, is that a bunch of like spoiled, entitled kids, right? That's the perception. Perhaps you all are changing that. You got guys like Mike Arias, right? President of CAALA, now the president of the state plaintiff's trial bar on the committees and going to Washington, D.C. You see the people we got bringing out here now, Brian Panish, Mark Hiepler, right? We're making a difference. We want you to be trial lawyers for the people, and that's why we're having this presentation. And the way to do that is to buy 4 books. Good segue, right? 4 books, Rules of the Road, Polarizing the Case, my #1 favorite book. I use it all the time. I just used it in a big trial last year. Polarizing the Case. Sorry, defense lawyers that are here. Becoming a Trial Lawyer, is unbelievable. I haven't finished that yet, but it's an unbelievable book. And then The Elements of Trial. Those are his 4 books. Get them and read all 4, trust me. Without further ado, Rick Friedman.
I've never been introduced by 2 people before. I wonder if we could turn that down a little somewhere. Maybe I'll put this down. Yeah, maybe that's a little better. All right, everybody still hear me okay? Yeah. So presumably we're all here because we're interested in trial advocacy, and probably the first lesson that you can learn, if you haven't already learned it, is that out of any bucket of facts, you can tell more than one story. So as much as I enjoyed that introduction, I'm always afraid I'm going to get an introduction such as the one my brother threatens to give me. Rick Friedman is reputed to be the only member of the Harvard Law School class of 1979 who failed to receive a single job offer upon graduation. While some claim this was due to his poor grade point average, others insist it was due to his abysmal personal and social skills. Moving to Sitka, Rick started a solo practice and for the last 39 years has teetered on the edge of financial bankruptcy without falling in. He's lost many prominent cases. If it's true we learn more from our defeats than from our victories, then Rick has much to teach us. So, same bucket of facts, just a slightly different spin. Second lesson is know your audience. So I need to know a little bit more about you. How many of you are 3L? 2L? 1L? Holy cow. Plaintiff lawyers. Civil defense lawyers. Prosecutors. Kind of. Public defenders, criminal defense. Yeah, okay. Judges? All right, we can talk about judges safely. Oh, we got one back there. All right. All right. I want to just say quickly, based on things that I heard this morning, especially for the first year students, don't worry so much if you don't know what you want to do. This is I don't even know what to call it. The legal community, the world of trial practice is extraordinarily complex and confusing, and it can seem overwhelming. On the other hand, it's really quite simple, and we'll talk a little bit more about that later. But you know, when I got out of law school, I never thought I'd actually be a lawyer. I just didn't know what else to do, so I went to law school. And I didn't know what else to do, and I didn't have a job, so I went to Alaska. And you know, so most of the people I know who are very successful trial lawyers, not all, but most of them didn't have the foggiest idea they would wind up being trial lawyers, even when they graduated from law school. So just explore, like people have said. So I've decided to try to take us on a little journey that will probably offend some of my friends in the room, but I'm going to do it anyway. Aristotle famously said that there are 3 types of persuasion available to the persuasive speaker. And the first is logos, which is logic, logical reasoning, which of course we're taught in law school. We go to CLEs and people teach us the logic of the law. We're steeped in logic. The second is pathos. That has to do with what's already residing in the audience, what's already there. So whatever your political beliefs, you can see in, for example, Donald Trump, he tapped into something that was already there. Is he the best speaker in the world? No. Does he use the best logic? No. But he was able to tap into the pathos of his audience. And that's always there. And in this day and age, you can hire jury consultants or, well, all kinds of people wanting to tell you what's already residing in your audience and how to reach out to them. The Reptile is all about that. Jury consultants, all kinds of books and articles. And then there's ethos, the thing that Aristotle, and let me just say, so I don't give you the wrong impression, I've never read a word of Aristotle. But I've read somebody who says that they read something one of his students read. And in fact, I read a book that said Aristotle hated writing. He thought it was a bad invention, thought it weakened the mind. And on the other hand, on Wikipedia, I read that he actually wrote a lot of books. So I don't know what to make of that. But at any event, the third one, ethos. What resides within the speaker? In our case, the lawyer. What is there about the messenger that can influence decision making? And Aristotle thought that was the most important thing. That was the most important, most powerful tool of persuasion. And yet, if you look around the legal community, that's the piece we spend the least time talking about. And we had a pretty good discussion this morning of about as far as it goes most times. You know, don't do anything, don't offend the jury by being rude, don't overstate your case, always be super prepared, don't lose your cool. And you know, you could search the trial literature and you're not going to find much more than that. This last third of the engine available to us. If you think about you yourself as an advocate, as a 6-cylinder engine, maybe 2 of them are logos, 2 of them are pathos, and 2 of them are ethos. And most lawyers are running on 2 cylinders, logos. Some are running on 4, logos and pathos. And very few have really paid much attention to their ethos beyond what we've heard this morning. And I got to thinking about why that might be the case. Why might it be that we spend so little time talking about ethos? I want to suggest to you today that the reason we don't talk about it much is because it's in conflict with something else we're taught, beginning in law school. And that is the idea, I'll call it the zealous advocacy ideal of the trial advocate. And you've all heard this, you know, the advocate is supposed to give the most zealous representation to the client that they possibly can within the bounds of the law. You're not supposed to do anything illegal or unethical, but up to that, everything's fair game. So the archetype we've been given is that of a neutral, or let's call it morally neutral technician, just kind of the way doctors are taught. I have a set of skills, I'll apply them to my situation, and or to the case at hand, and I could as easily be on the defense side or the plaintiff side, prosecutor, criminal defense. It's really all the same. I am just a technician, zealously representing whoever hires me. And that archetype, that ethic, I want to suggest to you is something we really haven't thought through all that well. As a profession, we've embraced that idea, we've welcomed it, and I think to a large extent, particularly for us plaintiff lawyers, it's been our undoing. But I think for the profession as a whole, it's been our undoing. And it's allowed some very lazy thinking, and it's allowed moral cover for people in our profession who do bad things. So, how did we get here? One historical point that some point to, this guy's name is Lord Brougham. That's how it's pronounced, I've been told. And he was representing the Queen of England, who had some legal proceedings against her by the king, and he was being criticized for defending the Queen, and there was a fear there was going to be a civil war, and how could he was a traitor because he was representing the Queen in this situation. And he basically says, an advocate in the discharge of his duty knows but one person in all the world, and that person is his client. To save that client by all means and expedients, and at all hazards and costs to other person, and amongst them to himself. Basically, you put your client ahead of everything. That was Lord Brougham. And the essence of what he's saying is client is ahead of everything. That's kind of the essence of professionalism. But then he says, the client is ahead of you. You put your client's interests ahead of your own interests. But then he goes on to say, and you put your client's interests ahead of everything else. Now, that makes sense in the criminal context where someone's accused by the government and they may be imprisoned, they may go to jail, they may be killed. And all the forces of society are arrayed against them, trying to get them punished. But another advocacy standard developed, which probably best articulated by Justice Sutherland, who talked about what the standard is for the prosecution. He may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. So now we've got two different ethical standards. And how did it come to be that in the world of civil law, we all decided to embrace the criminal defense standard? This is, basically, we have this choice. How is it we rejected the first and embraced the second? And who do you think benefits in society when we embrace the second? Who do you think, which standard do you think the R.J. Reynolds lawyers would gravitate towards? The asbestos manufacturers, et cetera, et cetera. So the difference as well is illustrated by the classic example. You've got a witness on the stand, you believe they're telling the truth, but as a criminal defense lawyer, you're going to try to impeach them anyway. None of us have much problem with that. We start to get a little queasy when we think about the prosecutor impeaching a witness he or she knows is telling the truth in order to get a conviction. In fact, the ABA makes that exact distinction. If you go to the ABA model ethical rules, you'll see they explicitly say, okay for the criminal defense lawyer to do it, not okay for the prosecutor to do it. So why did we, as civil lawyers, adopt the criminal defense standard? Why shouldn't civil lawyers be restricted from striking foul blows? Why shouldn't we have a duty to something higher than ourselves And yeah, maybe higher than our clients. I want to suggest that by adopting the code of the criminal defense lawyer, we've cut ourselves off from our own morality, which is the same as cutting ourselves off from our own humanity. And for our purposes here today, it's the same as cutting ourselves off from a big part of our own ethos, from a big part of those other two cylinders that we have available to us if we want to do the work of oiling them up and getting them working. You know, some people become trial lawyers with the idea, I'm going to go into court, I'm going to wear some nice clothes, I'm going to strut around the courtroom, I'm going to impress everybody with how smart I am, I'm going to make a ton of money, everyone will know my name, and things are going to be just great. And, you know, honestly, all of us have at least a little bit of that in us. But if that's all you have, why should the jury care what you've got to say about this case? If that's all you have, you're selling yourself short and you're selling your client short. The truth is that virtually everything litigators and trial lawyers do has moral implications. And that's also overwhelming at times. I can go to this expert who I know always says the plaintiff is grossly injured, even if nobody else will ever agree with that expert. Or I can go to a middle-of-the-road person who will call it totally straight. Or I can go to one of the defense people who's going to say, you know, somebody in a wheelchair is not really hurt. So I've got that choice. And so when I make that choice, I'm making a moral choice as well as a strategic choice, obviously. That we hide from the fact that every decision we make as trial lawyers has moral implications, that we hide from that fact is, I would suggest, something, we've lost something. I'm not going to say it's something to be ashamed of, but it's certainly not something to be proud of. It's done a disservice to us as individuals and to us as professionals. And that's exactly what the corporate culture demands of us. You know, it seems like in modern US society, we're constantly pushed towards the material and away from the moral. And the corporate culture needs lawyers who will feel good about coming in and defending the indefensible and doing whatever is necessary to defend the indefensible. So I want to suggest that if every civil lawyer was expected to bring their own ethics, their own morality to the table, the system would be better and we'd all be better. But we're not here to talk about social engineering, we're here to talk about trial and how to be the best trial lawyer you can. Advocacy. So let's get practical. Are these two cylinders worth anything? And if they are worth something, how can I oil them up and get them going? So let me address the worth anything. Some of you who've been practicing, who've been exposed to Jerry Spence, have heard him say, I've probably heard him say 40 times, anyone in this room can beat me. I always used to think that was kind of hyperbole, but I think he genuinely believes it. He'd say, the youngest lawyer in this room can beat me. if they are truly themselves and more true to themselves than I'm true to myself. And I don't agree completely with how he's expressing that, but I think what he's trying to express is what I'm trying to express. The power of ethos, that beyond the skill, beyond the techniques, which Rex was saying a little bit of today as well, beyond the techniques, there's something else, and it's a powerful force in the courtroom. But it doesn't just sort of, it doesn't just descend on you. There are a few rare individuals who just have that. But for most of us, if we want to use those other two cylinders, we've got to work at it. Some of you may know who Mo Levine was. I just came across an old tape that Trial Guides is selling of Mo Levine, a very famous, influential plaintiff's lawyer of the 50s, 60s, and early 70s. And Mo Levine's talking to a small group of people, and he's on tape. And I don't know how it's kind of fuzzy. I can't tell how the subject came up. He starts talking about therapy. And one of the people in the room said, he talks about how he was in therapy for 4 solid years, 4 days a week. And someone in the group said, well, did that help you as a trial lawyer? And Mo Levine said, it helped me in everything, including being a better trial lawyer. And then he went on to talk about why. I want to talk to you about Jim McComas, who is the best trial lawyer I've ever seen in my life, actually in a court. I was actually in the courtroom watching, by far the best. I used to play a little game in my head of if I was charged with a serious crime and I could hire any lawyer in the country to defend me, who would I pick? And it was always Jim McComas, even over people like Jerry Spence, F. Lee Bailey, Edward Bennett Williams. Jim McComas is an extraordinary lawyer. He's retired now. But this is what he had to say. The sincerity of a true heart is the only requirement of effective advocacy. No one wants to know that, because a true heart is so much harder to acquire than a few advocacy techniques. Clarence Darrow, not the best trial technician of his time, not the most successful trial lawyer of his time, not the most eloquent speaker of his time, but I would say the most highly developed ethos lawyer of his time. If you watch, and you could take politics as a starting point, watch public debates, you can tell the difference if you pay attention and you refine your perceptual skills. You can tell the difference between someone who's making a political speech because they think it's the right thing to do. They really, they believe it's the right thing to do. And the ones who feel passionately that it's the right thing to do. And you can also tell the difference between the people who are just mouthing the words that the focus groups told them to mouth. So if you accept that there is something here, and I heard the discussion this morning about, I came in at the tail end about technology and being able to use that, and this is the modern world, and the thing is, nothing in our lifetimes ever going to replace one-on-one interaction between two people. And when that happens, nobody's looking at their phone, nobody's thinking about their Facebook posting, they're engaged with another person. And how do you do that? For one thing, you have to engage with yourself. So how do we get these other two cylinders going? And to be honest, I'm still trying to figure that out. Some of us are doing a 4-day CLE on ethos, trying to explore this subject. 4 days of kind of, a variety of things. But in any event, the first thing is to recognize that those two cylinders exist, that there is something you have available to you that's not talked about in law school, really not talked about very many places at all. And recognize whether we're prosecutors, criminal defense lawyers, civil defense lawyers, plaintiff lawyers, or even judges, that our jobs involve moral decision-making. And the fact that we ignore the morality, the moral implications of our decisions doesn't change that. It just means we're unconsciously making moral decisions instead of consciously making them. So I'm not presumptuous enough to tell you what your values should be, what you believe in, what's worth fighting for, how you should live your life. But I am willing to say you ought to have values. You ought to have moral, I don't know what the right word is. You ought to have a moral compass that you're constantly fine-tuning, because it never settles down. There are always more moral issues to deal with. Those moral issues you should think about constantly. Don't let yourself off the hook. And you should let that thinking, that uncomfortableness, because sometimes your values come into conflict, often they do, but that discomfort, all of that, you should let inform who you are as a person and also inform your advocacy. Someone this morning, I can't remember if it was Brian or Rex, said, you know, this doesn't just start in the courtroom, it happens outside in the hallway and in the parking lot. Well, it's all of life. You can't, the whole thing, be who you are, be your authentic self. Well, what if you're a jerk? And probably if you're a jerk, you don't know you're a jerk. I mean, most jerks don't. And so how do you know you're not one? That's partly a facetious statement, but it's partly true too. You don't know what you don't know about yourself. And what you don't know that you don't know about yourself is probably hurting your advocacy. So, by saying there are moral issues, we're saying there are things to live by that will inform your trials if you let them. They're bigger than you. Some people never get past that. Some people never get past the idea that maybe there's something in the courtroom bigger than them. And some of them are very successful lawyers. Those who get past that usually don't get past the next one, which is it's all about the client. There's nothing bigger than the client. And this is the part that's going to offend people, I think, but there are things bigger than the client, like being true to yourself, being true to your own values. So, how might this work with the four categories of lawyers we're talking about? You know, one of the best criminal lawyers I ever saw, I got to see him select a jury. His name was Gail Frates, and he had been every kind of lawyer you can imagine, a public defender, a district attorney, private criminal defense lawyer, civil lawyer, but eventually he wound up as a prosecutor, and he came to our little town of Sitka, and he was prosecuting it was a second-degree murder case. And I was a young lawyer, and I went to watch him pick the jury. And as the prosecutor, he stood up, and he said to the jury, "Have you all heard about reasonable doubt?" Yeah. "That means we don't want to convict Mr. Smith unless we are all 100% convinced beyond a reasonable doubt that he's guilty of this crime, right? You'd all agree that would be the worst thing we could ever do as people or as a society, is to convict him if he didn't do this or if there's the slightest doubt. Will you all promise that you will not convict him unless you're convinced beyond a reasonable doubt? And he went on like that. There was nothing for the defense lawyer to say in voir dire when Gail Frates was done. So what was so powerful about it was, one, you could tell he believed it. As the prosecutor, he did not want to make a mistake. He did not want to send somebody to jail who wasn't guilty. And his ego was going to take a second step down and acknowledge that he'd rather lose than convict somebody who was innocent. Strategically, it was so powerful because he took away anything the defense could ever think to say in a voir dire. And the case actually settled before opening statements. I mean, that's how powerful it was. For a criminal defense lawyer, the moral compass part might go something like this. If I were charged with a crime, because I'm a lawyer, I would have all these skills available to me, all this knowledge of the law. And if I was going to be executed or go to jail for 10 years, I would use every single thing I could, every tool of the law to keep me out of jail. And since I have the right to do that, my client should have the same right. So it's sort of like an equal protection idea. We should all have the same right to get ourselves out of a problem with the government. That might be one way you'd think about this in terms of your own ethos. Your ethos could be, before you punish this person, I'm going to make sure the government's held to its proof. And more, maybe even as more important than that, I'm going to make sure he's treated with dignity and respect by everyone in the system. I'm not going to let the judge bully him. I'm not going to let the prosecutor call him names. I am going to insist that this trial will be respectful of his humanity. Even if he's accused of being a serial murderer, and even if I believe he's a serial murderer, he's a human, and I'm going to talk about something larger than him. I'm going to talk about humanity. Jim McComas used to say that every criminal trial is a referendum on the human spirit. And as I watched Jim over the years, I came to think he was, in real life, the most Christ-like person I had ever met. Because no matter what his client was charged with, no matter how horrendous it was, he would step in and do that case and insist that the humanity of his client be recognized. And he would get extraordinary defense verdict after extraordinary defense verdict. For civil defense lawyers, I have a little bit harder time with this one, but I'm going to try to work my way up to it. I'll take the hardest example, the tobacco companies. You might be a libertarian, and you might feel like, okay, my client had a marketing strategy of addicting children to cigarettes, knowing that if they got addicted as children, knowing that if we don't addict them as children, they're very unlikely to become addicted as adults. And so that was my client's marketing strategy, and it was successful to a large extent. And that's the free market in which we live in, and everyone has choices, and they could have quit anytime they wanted. And so I feel good about coming in and defending this client against this kind of a lawsuit because of my libertarian view of the world. But I'm not going to help them do things that are illegal. I'm not going to engage in foul blows. I'm not going to pretend that the plaintiff is faking when half his lung has been pulled out or whatever, all the stuff that they do. I'm going to play it straight. And I'm going to anchor myself in my values, which I firmly believe, and that's what I'm going to do. For civil plaintiffs, every trial that we do is weighted with other implications, moral implications. You know, typically you got a client with a back injury, and the client is saying, since my injury, I haven't slept well, I haven't had a good night's sleep in forever. And the defense says, well, that's not worth anything. You can't translate that into dollars and cents. You still have your job. And then we say, and I've been so irritable, it's really hurt my relationship with my wife. And, you know, we're going to counseling now because I just cannot seem to be in a pleasant place whenever I'm with her. And I don't take my son fishing anymore because I can't carry the canoe like I used to. And then the defense comes in and they say, you know, your marriage probably wasn't worth that much anyway, and you were not a good fisherman, and your son would rather be on the streets selling drugs, and you know, they do their thing, and that's the fight where they're saying, you know, the defense is saying this stuff doesn't really matter that much, and we're saying yes, it does, and that's a bigger issue usually than just what's going on with your client. It's really, what do we think, what is the meaning of life, if you will? What does it mean to be on this earth and be in constant pain? And how are we as a society going to respect that or not respect that? So if I could only give one piece of ethos advice, it would be to ask yourself this before you go into any court hearing or any trial, which is, why am I here? Why am I here? I'm here because I don't like the way this prison system treats people, and somebody's got to stand up for them. I'm here because I'm offended at the assault of big governmental regulations on the poor tobacco companies. I'm here because my criminal defense client never had half a chance in life, never had anyone stand up for him and recognize him as a human being worthy of consideration. That's why I'm here. And why you're there is going to change from case to case, and it's going to change throughout your life. If you pay attention, if you grow. And the amazing thing is, if you do that, you're not going to be as disrupted by the other side's bad conduct. You're not going to be as thrown off guard when the judge starts throwing her weight around. You're not going to be as, you're going to have an easier time keeping your eye on the ball. You know, the other thing, I think we have at least one judge here. I wanted to say, you know, the same thing is true of judges. Since there's only one judge here, we'll make this fast. But, you know, basically, if you think about a judge's job, on the one hand, there are the cases or the decisions that have to be made where there's clear controlling authority, and the judge has not that much discretion. On the other end of the spectrum, or the bell curve, there are the cases where the judge, there's no controlling authority. The judge can do whatever she wants. And then most cases are informed by the judge's own personal values. When the judges hide from the fact that their decision-making is, to a large extent, personal moral decision making. You know, other cultures understand this. Other cultures pick their judges by trying to find people who are wise and experienced and have had a lot of bad stuff happen to them. But at any rate, if judges hide from the fact that they're expressing their own values, those values still come out, but they come out maybe in an unconscious way, and they look like hypocrites, or they look inconsistent. At a minimum, their own values are less well developed. And the judges become expert in camouflaging their own personal beliefs and feelings. And I'm not saying a judge should just get on the stand and do whatever, or on the bench and just do whatever they want. But we shouldn't all pretend that they're not exercising their own personal moral authority, their own personal belief system. And if the judges would recognize that, I think they'd have an easier time making their decisions. If they recognize their own values have to play a role in things. They'd not be fighting the unconscious forces that are tugging and pulling at them. I guess to an extent it'd be harder too, because they'd also have to wrestle with these very difficult moral issues. What does a judge do if the judge does not believe in the death penalty and lives in a death penalty state and is assigned a death penalty case? Does the judge refuse the case? Does the judge take the case and hope to express their values by making sure the person doesn't get a death sentence? I don't know what the answer is, but most of these, well, many of these issues require a fair amount of thought and work to figure out where do I, and this is the question for all of you, where do I want to stand? Where do I want to plant my flag and say, this is me? This is where I've decided to put my blood and my sweat and my money, my family's future. And that's true with the smallest of cases and the biggest of cases. So, how do we, how can we fire this up? I want to go through this pretty quickly. Let me point out an uncomfortable truth. Everyone here is going to be dead in 200 years. None of us are going to be remembered. None of us. And some of us have more time than others left. But those of you who are young and presumably have a lot of time, it goes really fast. And so part of the point is, what's your personal journey going to be about? What's going to be the focus of your life? And so many in our profession are what I call hungry ghosts. And I think it's the Hindu tradition. I think Buddhists believe in this too. Like the Irish have leprechauns, the Hindus have hungry ghosts. And the hungry ghosts are creatures of another world who live amongst us, whose throats are very, very thin, and their bellies are very, very big, and they're constantly hungry, and they're trying to cram things down their throat to fill their big, empty bellies. And no matter how much they cram down, they cannot fill them up. And they go through life trying to fill up these empty bellies. And it's easy as a trial lawyer to be a hungry ghost. It's the next verdict, and it's the next newspaper article, or it's the next book, or it's the next something, the next wife, the next car. And the truth is, none of those things will sustain you, and none of them make it worthwhile. They're nice to have, and I'm not suggesting you live an impoverished life, but it is. It's like the ice cream and cake. you live on that and you will be malnourished and unhappy. But that's all that's available to the legal technician, the amoral legal technician. How can you hope to have any moral authority in front of the jury when you regard yourself as a hired gun doing whatever's in your own best personal interest? So I read a while ago about an astrophysicist who said that the job of an astrophysicist is similar to being on a treadmill chasing God. He said, gets up in the morning every day, gets on the treadmill, and has the greatest time, and he has no expectation of ever catching God. Maybe that should be the job of all of us, all lawyers, all humans, maybe. If you recognize that the practice of law is an invitation to take a moral and psychological journey all your own, you will find things that will sustain you. I guarantee you will. And when you find those things, they will make you a stronger advocate. So, I want to quickly talk, as I'm nearing the end of my time, about a couple points. Many of the wounds in the courtroom are self-inflicted. I'm reminded of a story I heard once about a woman who wanted a pet, so she went to the pet store, bought a goldfish, got a bowl, brought it home. Fish lived in the bowl for about a week. The water is getting dirty. She decides, I gotta clean it, but she has no place to put the goldfish. So she fills up her bathtub, puts the goldfish in it, goes, cleans the bowl, comes back. When she comes back, the goldfish that's in a big tub is swimming just around and around in a circle like this, same size as its bowl. Because it had spent so much time in that bowl, it didn't even know it could swim beyond that. And the truth is that our own personal psychological histories limit us in the same way. Most of our limits are self-set limits, set unconsciously. If you're not in touch with your emotions, with those unconscious limits, then it's very likely that those things will take you off guard and they will drag you down in the courtroom. So I always try to make a pitch whenever I talk publicly to really urge any lawyer to go to therapy. You don't have to be a great lawyer, you don't have to go to therapy to be a great lawyer, but I would say no matter how good you are, you'll be a better lawyer. Just like Mo Levine said, you'll be a better lawyer for having gone to therapy. If it were me, I'd require no one can be a judge unless they've had at least 5 years of therapy. So on the treadmill, we begin to understand there are things more important than ourselves, and we begin to shape ourselves. We learn that these things that are more important to us maybe are things like compassion, kindness, love, understanding. And in our culture, those things sound weak, but they actually are incredibly powerful. And what we find is that if we can embody those qualities in the courtroom, and you can't just embody them in the courtroom. If you don't live them every day of your life, they're not going to come with you into the courtroom. But if we can embody those in the courtroom, we have two cylinders that the other side probably doesn't have. So I'd like to leave you with this, almost leave you with this story. I'm in this I have this tendency to write things down and then not note where I took them. So I don't know where I stole this from. It's not my words. In the Protagoras, I don't even know if I'm pronouncing that right, Plato tells us tells us how it was that humans came by moral sense. Two gods were given the task of distributing qualities to each of the animals. Epimetheus gave the best of the qualities to the animals. He'd forgotten about the humans. Some of the animals were given fangs or fur or wings. He'd totally forgotten about the humans. When Prometheus came to check on how the task was going, he found that humans, had been left naked and defenseless. To help make up for the mistake or oversight, Prometheus stole fire and the mechanical arts from the gods and gave them to the humans as a way to compensate them. But it wasn't enough. The humans were too stupid, selfish, and mean-spirited. It was looking like the end of the human race, and then Zeus stepped in. He chose to give the humans the one gift they needed for survival and greatness. Zeus gave them the gift of a moral sense, and he made sure that he gave it to each, so that each would share in its saving grace. Then, as now, it is not fire or our mechanical cleverness or even manipulation that has distinguished us. It is our moral sense. And that moral sense is what distinguishes the truly great trial lawyers, many of whom none of us will ever hear of, from the ones who are just gratifying themselves and using their careers as a way to gratify themselves. I want to suggest to you that the highest aspect of being a trial lawyer is you get to explore yourself in your moral sense and who you are as a person. And the highest achievement of a trial lawyer is to morally engage in all aspects of the job, to use all 6 cylinders. And as you run on all 6 cylinders on that treadmill, you'll begin to change and shape yourself. And you'll be creating a work of art, not for everybody else to see, but for you to see and admire and keep changing and keep improving. You'll be creating a work of art for your sole enjoyment. And incidentally, you'll be making yourself a much better trial lawyer, going on all 6 cylinders. So, I hope you all have fantastic careers on your moral journeys. Thank you.
We appreciate those words and the fact that you seek to challenge all of us in here. We have something for you, so hopefully you aren't going too far. Each year, we've started the tradition last year of naming a trial lawyer of the year, and I want to go through the reasoning that we went behind this, behind naming Rick Friedman as the 2019 trial of the year. We want to choose someone that has an impact on the community and the trial lawyer community, but also someone who's done something significant over the past year. Rick Friedman is a machine. He writes novels, writes books. When I first got to my own law firm in Colorado, that was the first book that my senior partner had asked me to read was Rick Friedman's Rules of the Road, and I know that's happened in a lot of firms around here. I heard Spencer say that earlier. And when you're new to the practice of law, not just law school, it's interesting that you're introduced to all these phenomenal folks that you just haven't had the occasion to hear of. Marcel and I, before we came to law school, we were Marines. We'd be Chesty Puller, we had all these names that we knew in that world. Now we're in this lawyer world and we're finding out these new names, and Rick Friedman was one of those names. So we had the opportunity to have him out here this year. It was just so incredible to me personally, and I know a lot of you in here have read his works for many years, so we were honored to have you, sir. Really appreciate the impact that you've had on all of us. just in case you thought Rick Friedman was resting on his laurels, I want to read a little bit about a case within the last year. April 23rd, 2018, a Kentucky jury awarded a $67.5 million verdict to two former coal miners, brothers Leslie and Michael Cox, who alleged defective dust masks, respirators, which led to their black lung disease. The jury awarded compensatory damages for past and future pain and suffering, but the bulk of the award, $62.5 million, was awarded as punitive damages against the manufacturer 3M Company. The judgment is thought to be one of the largest ever reported in eastern Kentucky. Coal miners wear respirators to filter out coal dust. Breathing in coal dust causes black lung, an incurable condition that chokes off breathing and often leads to death. After a three-week trial, the jury ruled that the Model 8710 respirator manufactured by 3M was in a defective and unreasonably dangerous condition, and that an ordinarily prudent manufacturer of similar products, being fully aware of the risk, would not have put it on the market for use in coal mining. The jury also ruled that 3M acted with reckless disregard for the safety of the Cox brothers and others, justifying the extraordinary punitive damages award. The Cox brothers were represented by Rick Friedman, alongside co-counsel from Kentucky. During the trial, Rick used his nationally recognized rules of the road, on sale in the atrium, method to identify important rules and principles that a defendant should have followed. Among the rules identified in this particular case were: 1, a manufacturer should not sell a respirator and say it provides protection against black lung when it does not provide such protection. 2, a respirator manufacturer should promptly inform users about safety risks that it learns about. And 3, even if the government allows an unsafe practice, a respirator manufacturer should not engage in that unsafe practice. Given their award, the jury understood the rules of the road that applied to 3M's conduct and arrived at an appropriate verdict. This verdict was 1 month after Mr. Freeman had assisted his clients in winning a police brutality case in Tacoma, Washington. And then, if that wasn't enough of a 2018, at the end of last year, Mr. Freeman appeared in a documentary called The Bleeding Edge, which was on Netflix. Many of you may have seen it, which was a disturbing but fascinating documentary about the business of medical devices. I think there's ample evidence to suggest that this is the right person to choose, and we're honored to name you this year, sir, as our 2019 Trial Lawyer of the Year. We're going to go ahead and take a 15-minute break, and then we'll have our last panel of the day. Please visit our vendors. We're so honored to have them. Thank you all for your energy and enthusiasm. One panel left.